Today's courtroom drama is a landlord's nightmare and a tenant's ticking time bomb. Judge Boyd is about to rule on a case involving bounced checks, missed hearings, and claims of mental health struggles. But here's the twist. The defendant, Catherine Yoder, hasn't paid rent in months, yet claims her balance is zero. You heard that right. This case is packed with emotional appeals, legal confusion, and a last-ditch plea to avoid eviction. Right before Christmas, will the judge buy her excuses? Or will he slam down the gavel with finality? Stay tuned, because this hearing spirals fast and ends with a serious eviction bombshell.
Cox Law Firm. They're very busy. We did call and clear the state to see if they would have somebody available, and apparently Ms. Zannon drew the short straw. So here she is. So let's back up. The plaintiff sued for black rent in a non-payment of rent case. At the time the matter was filed in September, the arrearage was $1,186. Now, we just had a previous case, 2412.
Already, this case starts off messy. Catherine Yoder is dialing in by Zoom. While legal aid and attorneys crowd the courtroom, it's clear everyone is ready, except the defendant. The judge even jokes that one attorney drew the short straw to attend. That kind of tension is never a good sign, and when a judge starts off sarcastic, you know he's not in the mood for nonsense.
On November 15th. And let me look at the signed copy. The defendant, here it is. That was on November 15th. The amount of rent was $718, $184.47, and for a total of $902.47 due by November 25th, or the defendant was subject to eviction. As I indicated, she was personally served. She did not appear. We got an email from the defendant on December 4th.
Let's break this down. Yoder was personally served, missed her court date, and didn't respond until nearly 3 weeks later by email. Not a formal legal motion, no court header, no filing fee, just a casual message asking the court to undo a judgment. That's like texting your professor to undo your final grade because you meant to study. The legal system doesn't work on casual vibes.
Aside, I was unable to make rent payments for the month in question because I was not working during that month due to challenges. I live in an income-based apartment and technically should not have been required to pay rent during those months. As I indicated, we just resolved another case of the same tenancy in August. I understand the importance of meeting financial obligations and other important meetings such as the scheduled court dates that I failed to attend. I did not attend to avoid my responsibilities. Fortunately, due to my mental health challenge, I was unable to respond to the lawsuit in a time.
Here's where it gets tricky. Yoder claims she shouldn't have had to pay rent because of her income-based apartment, but legally, that's not how it works. Even in subsidized housing, rent isn't automatically waived. You must notify management, request recertification, and follow procedures. The judge needs more than broad claims and emotional appeals to reverse a legally binding judgment.
And I set this emergency hearing. As a general rule, when a party moves to set aside a default, they have to show, they're supposed to file a meritorious, an affidavit of a meritorious defense and show good cause for why they didn't show up. The defendant had shown up for hearings in August. She was personally served. She didn't show up for this one. She makes some veiled reference to the fact that she had mental health issues. I'm not sure that rises to a legitimate reason for failing to appear, and a meritorious defense. Her defense, I guess.
To set aside a default, two things must happen. You need a valid excuse for missing court and a legitimate defense. Yoder offers neither. Her defense is vague and her reason for missing court is loosely tied to mental health, with no documentation. It's like showing up to a speeding ticket trial and saying, "I was stressed, Your Honor." It might be true, but it won't win the case.
So, we asked the Cox Law Firm to be here. We forwarded a copy of the defendant's email to them, and Attorney Carrie Zanin is here. Ms. Zanin, what's the plaintiff's position?
Well, Judge, was going to argue the court rule. I don't believe that good cause was, well, first, I don't think we even need to get to the good cause and the meritorious defense, as this motion should have been filed within 10 days. And motion email, the judgment was signed on the 15th, 10 days would have been the 25th. She's an additional 9 days beyond that date. I don't believe she's, in compliance with the court rules as to the time frame, and I don't believe she's delineated good cause to set aside. She was personally served. She had the court date. She didn't appear, and I don't believe there's a meritorious defense either. As to your questions about the August, I can tell you by looking at the ledger, she did make a payment late in August that brought her balance down to $70, and that's probably why the dismissal. And then, of course, September, October, November, and December are now due. So I would ask that you deny the motion.
Now the plaintiff's attorney drops the hammer. Not only did Yoder miss deadlines, she's 9 days late past the 10-day appeal window, even if the court were generous. Her email still doesn't cut it as a proper motion, and there's no affidavit of defense. Translation: there's no legal meat on this bone, just excuses and delays.
Oh, is 9/23. So there's been small payments made since the date of the judgment. The only payment that shows is the utility reimbursement, so I apologize. But what I'm showing at this point with December is that she owes $923. So an extra $20, Judge, on the judgment.
All right. Now, sometimes there are a couple things. When you fail to appear in a landlord-tenant case, you have 10 days to appeal. And you didn't file anything within 10 days. You filed it on December 4th.
Let's talk technicalities. The judge explains that in eviction cases, unlike other civil suits, you've got a tighter clock, 10 days to appeal, no exceptions. Yoder waited 19, strike 1. No proper notice to the other party, strike 2. No affidavit of defense, strike 3. This isn't just bad lawyering, it's legal self-sabotage.
There's no meritorious, well, it's multiple. You didn't properly file it. It was filed more than 10 days after the appeal period. It wasn't served on the other party. We served it. You didn't file an affidavit of meritorious defense. And I'm not sure there is a meritorious defense. You simply owe the rent. Somehow it's your contention that it shouldn't have been calculated as this, but we just had another case about 3 weeks before it. And you're employed now and working somewhere in what looks like a good job. So they want to stand by the original order. That's now 9/23.
Now here's the jaw dropper. The check Yoder gave the court bounced because the account was closed. That's not just a failed payment. It's potentially criminal in many states. Writing a check on a closed account is a misdemeanor. This case is no longer just about unpaid rent. It's about credibility and the judge's patience running out fast.
Ms. Yoder, what's your position?
I'm wondering, what job do you feel that I have? I've been unemployed
Well, you said
since
you were
July.
out of state at a conference.
That is not related to work, Your Honor.
Oh, okay. I thought it was.
And I've been unemployed since July 25th. And the reason why I've not, she's giving me the $528 rent fee for August is because I neglected to let her know that I quit my job at Gemstone Solid Surfacing in Elkhart, Indiana, July 25th. So she's putting that $528 for rent in August, and then the extra fees are the court fees for the missed court hearings that I missed. So how am I supposed to pay for that with no job? Plus, I've had interviews. I've applied for over 30 jobs remotely and out of in the workforce, and I've not been able to get hired. For that reason, I really don't know, other than the fact that I've been trying to do my best.
Well, I respect that, but none of that's a defense of the fact that you haven't.
Let's pause here. Yoder says she's applied to over 30 jobs and is trying her best. And while that may be true, the court isn't here to judge effort. It's here to enforce contracts. You can empathize with her struggle and still understand. That rent is a legal obligation. Courts can't function on sympathy alone. They need structure and evidence.
All right, so she owes August rent, but she's zero currently.
Yes, September 1st, she went down to 0 rent.
All right, so how do we get 923?
Let me look at her ledger. She had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us she didn't raise any of this. She said she was going to pay it. And then some checks bounced. And let me back up. We were here on November 4th. She wasn't here. On November 4th, another attorney from Cox law firm, Jen Wilburn, was here, and Ms. Kalmbach was here. Defendant had brought in a check. She was nervous about it. She wasn't sure it would clear. The arrearage was $658, and that was through November, and it was $184.47. So it didn't include, she brought in a $658 check, but did not include legal fees. So she missed the first hearing on November 4th, but because the check had come, I waited to see if it cleared. I continued it to November 15th. Ms. Kalmbach indicated that the check had bounced and did not clear. The defendant did not appear, and I issued the default judgment. 718, 184.47, and 902.47 total. The check came back as a
This moment seals her fate. The judge gave her extra chances, continued the hearing, held off default, and what did he get in return? A bounced check and no-show. That's courtroom betrayal 101. Judges may be lenient, but they're not blind. And once your trust with the court is gone, so are your chances of redemption.
All right. So,
Your Honor, could I add something else?
yes.
Back in July or August, I believe, the landlord came in to check my ceilings, and she had said that she was going to come get them fixed. And when you look at my ceilings, I can provide photo evidence as well if you need that. It's bowing down. And there's been 2 other tenants that I know of personally whose ceilings have caved in and fell.
Stop. The time to raise that defense was at the time of the hearing. We were all here. Now you haven't paid the rent. You didn't file it in a timely manner. You didn't file it properly. You didn't file an affidavit of meritorious defense. And now you're raising some habitability issue that you had 2 opportunities on November 4th and November 15th to raise. So I adjourned it because you had presented a check. Not only did it bounce.
At the last minute, Yoder tries to pivot to habitability issues, claiming her ceiling was caving in, but it's too late. The judge shuts it down instantly. Why? Because if you want the court to consider your defense, you must raise it in the hearing. Surprise evidence doesn't fly. This isn't a courtroom TV drama. Timing matters as much as truth.
I don't believe I've received it yet. Let me look.
I would rather pay the $528, meet you in the middle with that. I'm going to have to get some help, but I would be glad to do that because I don't have anywhere to move to right now.
Yeah, I do have the writ of, they don't want you to do that. I did get the writ of restitution eviction on December 9th. The motion to set aside the default is denied. It's outside of the 10-day appeal period. Even if it was considered that it was filed within 28 days, there's no good cause shown for failure to appear. and there's no affidavit of meritorious defense. They don't want you as a tenant anymore, and it's going to show as an eviction on your record, which may make it very hard for you to get into any other subsidized complex. They don't, theoretically, this order will allow them to evict you tomorrow or Monday morning. But maybe they can work out some sort of accommodation or agreement. But I will sign the writ of eviction. So you're in a difficult spot. It's right before Christmas. You had two opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound, your current rent is zero. You're not going to be able to find rent for zero. So my suggestion is that you go in and meet with the manager and see what you can work out for a move out date. They don't have to serve this order for 56 days.
In the end, Judge Boyd denies the motion to set aside the eviction. Legally, she missed every deadline. Factually, her case lacked any solid defense. And emotionally, it's hard. She faces eviction days before Christmas, with no job and nowhere to go, but the law doesn't bend for holiday spirit. This ruling will hit her record hard and make future housing nearly impossible. If this case shocked you as much as it did us, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We break the legal drama, you bring the verdict.